Hey folks, my name is Shaunik, rhymes with Sonic, and I've been a lawyer for about 10 years. I am a plaintiff's litigator, which means I represent people, usually against big corporations and government entities. And I love the law. I love using it to fight for people every single day. Today, I'm going to tell you a story that every first-year law student knows. This is the story of Helen Palsgraf. In 1924, Miss Palsgraf and her daughters were standing on a train platform, waiting for their train. As they were waiting, a train went by, not theirs, but somebody else's train, and a man who was late ran and jumped aboard the train. He wasn't going to make it, and so one of the guards, the railway company's guards, helped him and pushed him across, and someone inside the train pulled him aboard. As he was getting onto the moving train, he dropped a package that he was holding onto the train platform. That package contained fireworks, and they exploded. That explosion caused some scales that were on that platform, large scales on the platform, to topple. And they toppled onto Mrs. Palsgraf. So she was hurt, not very badly. The harm was more psychological. She was in shock. She had what we would probably diagnose now as PTSD. She developed a stammer after the incident, and she sued the railway company. She won at trial. Now, the railroad company appealed to New York's highest court. The opinion was written by Justice Cardozo, who would later go on to become a U.S. Supreme Court justice. And Cardozo and the dissenting Justice Andrews were bitterly divided on sort of the reasoning behind this opinion. And it all came down to foreseeability. What the court ultimately held was that foreseeability was a requirement to establish a duty. The railroad company could not have a duty to somebody to protect against an unforeseeable harm. Andrews, in his dissenting opinion, said foreseeability is really more about causation, not duty. It's a question for the jury to decide. Was the harm that actually happened something that flows foreseeably from the conduct of the railroad company? So that debate, is foreseeability sort of a crux of duty, or is it a crux of causation? That has been ongoing for a century. And it's formed the basis for the law around negligence in most jurisdictions in the country. If somebody engages in conduct, they either do something or they fail to do something, and as a result of that, there is harm, that is usually the basis for negligence. It's not intentional. It's not like assault or battery. It's just you did something and then somebody got hurt because you probably should have done it better, or you probably shouldn't have done it at all. That's negligence in a nutshell. The elements, so these are the pillars of negligence: duty, breach, causation. The defendant, the person who is purported to be negligent, they have to have had a duty. And there are all kinds of different relationships that can create different kinds of duty. Like a landowner can have a special duty to somebody who comes onto their land. A stadium that's having an event could have a different kind of duty to people who buy tickets and go into the stadium. There's all kinds of different circumstances that trigger duties, that create relationships that otherwise wouldn't exist. You've got to have a duty in order for there to be negligence. Next is breach. Was that duty breached? That duty has a certain standard of care. For example, a very basic duty is to act reasonably. And if somebody with the duty to another acts unreasonably, then that act could be a breach of the standard of care. We're not going to talk a lot about breach today. We're really going to focus on duty and causation because of foreseeability. That brings me to causation. Causation is there was duty, there was a breach of that duty, and the conduct that breached that duty flowed to the harm. There was a causal link. In a lot of jurisdictions, causation has two parts: actual cause and proximate cause. Actual cause is also known as but-for cause. It's like the most direct causal link you can think of. But for defendant's conduct, the harm would not have occurred. But that's not all that's required for legal causation. The second piece of the causation puzzle is proximate causation. And this is more of a policy determination. It takes into account a lot of different factors to determine whether person who engages in this type of conduct should be held liable for this type of harm. Does it make sound policy sense? Do we as a society think that's appropriate under the law? That's proximate causation. So one of the factors that you look at in proximate causation is foreseeability. Others are, how close in time and space these things happen, but foreseeability is a big one, and that was the one that was discussed a lot in the dissenting opinion in Palsgraf. Now, the nuance between foreseeability in the context of duty and foreseeability in the context of causation is something that even a lot of experienced lawyers kind of have a hard time wrapping their heads around. But foreseeability in the context of duty is really around the question of, should we impose a duty for this type of conduct? So when a court is deciding whether a duty should exist under the law, one of the things they're looking at is foreseeability, which is to say, is it foreseeable that this conduct or this type of conduct could result in harm? And if so, then we'll impose a duty. Now, there are a lot of other factors there, but foreseeability is a big one. If so, we will impose a duty. That is a very prospective lens. When you're evaluating foreseeability in the context of causation, first of all, it's generally a fact-specific determination. Fact questions go to the trier of fact, which means that at trial, the jury, if it's a jury trial, or the judge, if it's a bench trial, will decide whether, as a factual matter, the harm that happened to the plaintiff specifically was a harm that was a reasonably foreseeable result of the defendant's conduct. It's a hindsight type of question. You're looking at the things that happened and saying, was it a reasonably foreseeable result? Duty, it's a foresight kind of question. Could this kind of conduct result in harm broadly? You kind of narrow the foreseeability question as you get into causation. That's a lot of nuance, but it's important to know there is a difference in foreseeability in the context of duty and causation, but foreseeability is kind of a pillar of both. Now, whether you're talking about duty or causation, foreseeability is kind of a moving target because it changes based on new developments and societal expectations. For example, post 9/11, there was a broader set of foreseeable circumstances in a mass transit situation than there was in the 1920s, because there has been so much development, both of the technology in mass transport and the types of incidents that have occurred in mass transport, that more is reasonably foreseeable. So over time, foreseeability changes, it expands, more things are foreseeable. You could say that fewer things are foreseeable too. For example, it's probably not foreseeable that you're going to get hit by a horse-drawn carriage going down the freeway. But maybe that kind of thing was more foreseeable, 100 years ago when cars weren't prevalent. So as things shift, foreseeability shifts. Foreseeability is also a moving target specifically with respect to whatever situation you're dealing with. Let's just take the Palsgraf situation. Let's think about those scales for a sec. Giant scales, they were tipped over by the fireworks explosion. I'm not going to focus on the fireworks because I think even now it would be hard to make the case that exploding fireworks themselves could be foreseeable in any kind of situation. But you can focus on the other pieces that were happening there. So the scales. Maybe the scales weren't secured properly. So if there had been multiple prior incidents where the scales had tipped over and hurt someone, or had just tipped over without hurting someone, well, maybe the scales tipping over becomes a foreseeable result. Or maybe the guy who was jumping onto that train, was he a known quantity? Had he done this before? Had he jostled people out of the way while running to catch a train late, knocked people over? Had he been cited in the past and noted it had happened before once or twice or three times? Well, then maybe it's foreseeable that this particular gentleman would take action that would result in someone being hurt. And if so, then the question would be, did the railroad company do enough to prevent against the type of harm that it knew was foreseeable? And that's where you get into, was the type of harm actually suffered here something that reasonably flowed foreseeably from the conduct? Now that you are an expert on negligence and duty and causation, I'm going to throw a wrinkle in there. And I'm going to talk to you about common carrier duty. Common carriers are carriers of people, trains, planes, Ubers, lifts, taxis, roller coasters, believe it or not, elevators, escalators, moving things that transport people from a place to another place. They're called common carriers. And common carriers have a heightened standard of care and a heightened duty. As a society, we determined that if there are carriers who hold themselves out as being responsible for and being specialized in carrying people from place one to place two, and people rely on those carriers, then it's really important that those carriers have a heightened duty to make sure that the people they're carrying are safe. It is the duty of the utmost care. Usually, the duty is reasonable, what a reasonable person in that situation would do. But a common carrier duty is higher. Now, in the original Palsgraf case, common carrier didn't apply. Why? Because Mrs. Palsgraf was on the platform. And back then, and still in many jurisdictions today, common carrier does not trigger, does not attach unless you are a passenger. If she had been stepping onto the train when that package exploded and the scales tipped over and hit her, the calculus, I think, would have been different, because then common carrier would likely have attached at the point at which she is entering onto the train. The railroad would have had a heightened duty towards her. And while a common carrier duty is still limited by foreseeability, the scope of that foreseeability is wider. What is foreseeable is wider because the duty of care is higher, because the standard is higher. Now, the common carrier duty applies today. If you're getting on a train, a subway, a plane, like I said, an Uber or a Lyft, anything that's transporting you, those folks have a higher duty of care towards you. One thing I think is really important when talking about the law, sort of in the abstract, is to remind myself and everybody else the very human impacts of these legal decisions. Helen Palsgraf was a mom taking her 2 kids to the beach. Okay? She did nothing wrong. And she was hurt. She was traumatized. She developed a stammer. She went mute. And at the end of this case, when the highest court in New York ruled against her, she was ordered to pay the railroad's costs, which amounted to about 1 year's worth of salary for her. Here was a person who did nothing wrong and had to pay a year's salary because they were hurt. And all they did was try and seek redress in court. This brings us to the larger policy question. Do we think it is fair and just to have a society where somebody can be injured through no fault of their own because of the actions of somebody else, but be left with no means to collect monetary compensation for medical bills, therapy, whatever they may incur as a result of what happened to them? As a just society, do we think that that is fair? Or do we as a society think it is just and fair to allocate risk differently? Not equally amongst everybody who lives and works in the society, but equitably, in a way so that larger entities with more financial means and stability bear more of the risk, so that larger entities that bear more responsibility bear more of the risk. That's an important question. Do we think risk should be allocated equally or equitably? And that brings me to, I think, a video I'm going to do in the future on insurance, because that's exactly what insurance is. The existence of insurance. I'm talking health insurance, auto insurance, home insurance, renter's insurance, liability insurance. The existence of insurance has wildly skewed how we allocate risk in society. It is most certainly not an equal allocation. I don't know that it's an equitable allocation either, but it's certainly something to talk about because, insurance actually plays a huge part in lawsuits. And I'll talk about that in a future video. But for now, if you thought this was interesting, but you're wondering, why does a 100-year-old case still have any bearing on how we view the law today? Well, then check out this video, which I did on how precedent affects the law, because I think you'll get a little more context from that and have a deeper understanding of why that's the case. Otherwise, I'm glad you stuck around. I'll see you next time.